So the rights of nature is a relatively simple concept. It's about ecosystems, rivers, bays, forests, mountains, having legally enforceable rights under our system of law. Under our Western system of law, human rights are the highest and best protections that we have to protect certain values that our society wants to respect. And nature, unfortunately, under our system of law has always been treated as property, so that the more property you own, the more ecosystems you can destroy under the system of law that we have. So the bundle of rights that comes with that property ownership includes the right to destroy the property or the right to destroy the ecosystems on that property. So nature has never been protected to the same extent as human rights have been protected under our Western system of law. And this is about changing that, to shift to a system where nature is protected by those highest levels of protection afforded by a Western system of law, namely the protection of rights. And nature having rights is a very radical concept to some people, but it is an indigenous value system that's been held for thousands of years by indigenous and native communities, that nature itself is not property, that it has some status other than property that needs to be respected and not violated. In the 1970s, a law professor from the University of Southern California, Christopher Stone, wrote a law review piece called "Should Trees Have Standing?" And a lot of professors and lawyers trace their understanding of rights of nature back to that law review piece, "Should Trees Have Standing?" And it, for good reason, it ended up as a part of a dissenting opinion by Justice Douglas on the U.S. Supreme Court in a case called Sierra Club versus Morton, in which the Sierra Club was trying in the 1970s to stop Walt Disney, the Disney company, from building a ski resort in Mineral King Valley in California. And the Sierra Club had brought an action to stop that ski resort from going in. The Sierra Club was dismissed in the case as a result of not having what's known as legal standing. So the Sierra Club members who cared about the valley did not allege enough in the complaint for a judge to find that they actually had a legal standing to continue the complaint. So in other words, to be a party. And Justice Douglas, in his dissent in the opinion, and Christopher Stone, in his law review piece, "Should Trees Have Standing?" Both expressed a desire that the legal system essentially recognize that people have standing on behalf of those natural systems, ecosystems like Mineral King Valley, and didn't have to show some kind of personal injury to themselves to actually be able to defend the rights of that place, but that people should be able to stand in the shoes of those ecosystems to actually defend those ecosystems from projects like a ski resort in Mineral King Valley. And so while most people trace, at least in modern legal culture, back to those 1970s events, whether that was the law review article or whether that was the dissent by Justice Douglas, rights for nature, rights of nature, really an indigenous native value that travels much further back than those 1970s, the law review article or the decision in the Sierra Club versus Morton case. Following that case, Sierra Club versus Morton, there was an attempt to bring a bunch of lawsuits on behalf of animals under the Endangered Species Act. So you had a case dealing with a plaintiff being the marbled murrelet bird species. You had loggerhead turtles being plaintiffs in cases in Florida. None of those cases went very far because the courts decided that the Endangered Species Act only allowed people to bring lawsuits on behalf of themselves, but not for animals or ecosystems to bring suit on behalf of themselves. And so 14 years ago, in a small place called Tamaqua Borough, northwest of Philadelphia, the small borough of Tamaqua was faced with a plan 14 years ago to put 700,000 tons of PCB-laden dredge from the Hudson and Delaware rivers into old mine shafts in the borough of Tamaqua. And the people of Tamaqua were not especially excited about being used as a toilet for PCB-laden dredge coming in from these dredged rivers into Tamaqua. And so they took a stand and they passed a law that banned that dredge from coming in, but in the process recognized that the rivers and ecosystems within Tamaqua would be as damaged as the people in the community itself, and passed the first one in the world, law recognizing the little Schuylkill River within the borough as having rights to exist and flourish and thrive, the kind of standards that we see today in these rights of nature laws. So Tamaqua was the first. Then the Ecuadorian Constitutional Assembly, hearing about what happened in Tamaqua, brought us in to assist them with drafting the new Ecuadorian Constitution. And that new Constitution contained, for the first time in a national constitution, a rights-based system of environmental protection, recognizing that ecosystems in Ecuador had certain rights to exist, flourish, and evolve. That then resulted in a series of lawsuits in which ecosystems became plaintiffs in those lawsuits. So it sometimes bends our brain a little bit to understand that ecosystems are plaintiffs in these cases, not humans or not human groups or municipalities, but actual ecosystems themselves. The first case was known as the Vilcabamba River versus the province of Loja. And so the Vilcabamba River as a plaintiff suing over road debris, construction waste that was being dumped into the river, changing its course. And in the first decision ever, a judge in the Vilcabamba case ruled in favor of the river, an injunction against the dumping of the road debris waste. Since then, there's been a bunch of cases in Ecuador dealing with illegal gold mining, shark fin fishing, a bunch of different ecosystem destructive practices in Ecuador to stop them. And then the work has traveled. It's traveled to other countries who have adopted laws, like Uganda last year adopted rights of nature within their National Environmental Act. Courts in India and Colombia, legislatures in Bolivia and Mexico, localities in the United States, and other places working to protect things like the Great Barrier Reef and the Himalayan mountain range, using rights of nature to advance those kinds of laws. In the United States, the laws have been used to attempt to intervene in various court cases on behalf of ecosystems like watersheds. They have been met with limited success. But as more and more places begin to adopt these rights of nature laws, you're going to see more of those types of intervention and challenges into that process of law. And that's what we're seeing today, is more and more efforts on behalf of this rights-based system of environmental protection. So in some places, folks, the opposition has come in mostly from some of the corporations affected by the projects or by large landowners, and they'll say, well, we can't pass a rights of nature law here because I won't be able to cut my lawn, or I won't be able to drive my car. And the important thing to understand about the rights of nature laws is that they're about ecosystems. They're about systems. They're about natural communities. It's whether your activity has an impact on that particular community or ecosystem, that bigger system. And my favorite story was from New Hampshire, when somebody stood up at one of the meetings in rural part of the state and said, well, this means I can't cut down a tree in my yard if we pass this rights of nature law. To which the guy next to him, another old timer from the community, said, no, Ralph, that's not what it means. It just means we can't cut down all the trees. And so it's about these systems, these natural communities and systems. It's not about an individual blade of grass or an individual tree. It's about ecosystems as a whole. That's how the rights of nature laws try to increase and provide that enhanced environmental protection.